Hi, everyone who's joining us right now. We are just going live, so we'll give it a minute to let everyone trickle in, and then we'll go ahead and get started right at noon. Okay, great. Thanks everyone for joining us. Looks like it's now noon, so we welcome everyone to the San Diego Defense Lawyers August CLE presentation. We have a excellent speaker lined up to talk about writs and their importance in litigation. And to introduce her, I will introduce Lawrence Zucker, who's a San Diego Defense Lawyer board member, to tell us who our speaker is going to be.
Thanks, Ian. Good afternoon, everyone. Thanks for joining us today. As he said, my name is Lawrence Zucker. I'm the managing partner over at Haight Brown and Bonesteel San Diego office, and I'm currently the secretary for SDDL, as well as the golf chair. And I want to plug a reminder right now that everyone should get over to the website and sign up for our golf tournament, as tee times are filling up relatively quickly. This year's tournament is October 7th, so don't forget to get over there and sign up, please. Without further ado, I'd like to introduce you to my partner and appellate specialist for the firm here, Arzu Jamshidi. She will answer all of your questions at the end of the presentation. Thanks for attending.
Thank you, Lawrence, and thanks for having me present on this, what I think is an important issue anyway. And just as a reminder, I believe Ian has dropped the PowerPoint presentation in the chat. So if you want to print it out or review it while we're going through this presentation, just go ahead and download it in the chat function there. So the first thing I want to do is talk about what this presentation is and is not. This is a presentation about writs in the state appellate court versus the federal appellate courts. And it will not be discussing writ practice in the trial courts, such as writs of possession or writs of attachment, typically seen in enforcement proceedings. And this presentation is also not intended to give you all the information that there is to know about writs. But it is intended to provide you with the basics and with enough information so you know how to utilize writs in your litigation practice and when to utilize writs in your practice. And as Lauren said, I will be happy to answer any questions at the end of the presentation. So without further ado, let's begin with the most basic question. What is a writ? Technically, a writ is an order that the reviewing court, usually here the Court of Appeal, issues to an inferior tribunal, which here for our purposes will be the Superior Court. Now there is a whole body of rules for limited cases where the appeals go to the Superior Court, and there are possibilities for writs there, but for purposes of this presentation, it will be writs from the Superior Court to the Court of Appeal. So the main purpose of the writ proceeding is to allow parties to have an unfavorable ruling challenged in the Court of Appeal. And it's not just any unfavorable ruling, it's rulings that are not appealable. So if you think of writ proceedings, think of it as a secondary system to appellate review. We already have a primary system where there's a possibility for direct appeals to the Court of Appeal, and you have a right to those appeals. But the writ proceedings should be thought of as a secondary system to the original system of direct appeals. And it allows you to challenge orders and rulings that are not directly appealable to the Court of Appeal. So how does it impact a case and the timeline of the case, and what does it normally look like? So I think it's important to kind of see it in that context. So in a normal case, you have your complaint and you might file an answer, or you might decide to file a demur or a motion to strike. Let's say that motion to strike or the demur is overruled, motion to strike is denied. So you got to keep moving through your case, because those orders are not directly appealable. So then you go on to discovery and to discovery motions. And let's say the trial court issues an order on your discovery motion. Again, that order is not directly appealable. So you have to keep moving through your case until you can challenge that ruling, which won't be till final judgment. So you keep moving through your case. Maybe it gets resolved through an MSJ, or maybe you have to take it to trial. And if you take it to trial, most likely you'll have some post-trial motions. And then you will finally get a judgment in the case. And that's where you will be able to review and challenge that order, overruling the demur, the order denying your motion to strike, the order granting that discovery motion against your client, maybe even your MSJ order that was denied. That's your opportunity to challenge all those rulings. And this is the typical course of a case. So you'll finally get your shot at your appeal. But writ proceedings provide that secondary system of appellate review. And the most important thing is that you don't have to wait. So instead of waiting until the very end of the case, that demur ruling that was overruled, you can challenge it by a writ proceeding. That discovery motion that was granted against your client, that can be challenged through a writ proceeding. The MSJ that was denied before you had to go to trial, that can be challenged through a writ proceeding, and you don't have to wait to the very end of the case. So that's one of the advantages of a writ. Of course, this secondary system that they've created to review orders and rulings isn't as easy as an appeal anyway. And that's because you obviously don't want the ability of a party to run to the Court of Appeal after every single decision in the trial court. We have a system for that. We have appeals that try to prevent, constant disruptions in the litigation process. And so the writ proceedings, there are some important differences in writ proceedings versus an appeal. And one of the biggest differences is that writs are discretionary. The Court of Appeal does not have to hear your writ. They can summarily deny a writ without giving you any explanation, whereas in an appeal, those are mandatory. And that means that you have a right to have your appeal heard, and you have a right to have the Court of Appeal issue an opinion in your appeal. But on the flip side, a writ gives you an opportunity to correct erroneous rulings early on in the case without having to wait until the end of trial, which is one of the advantages of a writ and why I think it is important to consider when you're litigating your case. So some of the advantages and disadvantages, we've already talked about the first one, which is you don't have to wait until the end of your case. You also get a speedy resolution. And what I mean by that is that in a typical appeal, from the time you file your notice of appeal until you get an opinion, you're looking at 18 months to even up to 2-3 years before you get a decision. but the actual writ proceedings move a lot quicker. So by the time you file your writ till you get a decision is typically less than a year, but even I've seen it 6 months. So the actual process is quicker as well. A successful writ can have a really great impact on your case. And it can really change and pivot the entire case before having to wait till the end. And although this isn't always seen as a positive, obviously a summary denial of a writ, it is important to note that it is an advantage to the effect that a summary denial doesn't have a binding precedential effect. So just because you get a summary denial doesn't necessarily mean that the Court of Appeal did not agree that the trial court erred. It just means that you may, and most likely means that you probably didn't meet some of the requirements that you're required to show when you file a writ. And we'll talk about that a little bit. And some of the disadvantages of a writ that you should consider are, of course, cost. Most writs aren't as costly as a full appeal because typically with an appeal, you may challenge a number of rulings. Whereas with a writ, you're focused on a single ruling, but of course, you have to consider the cost when determining whether a writ is right for your case. Another one that we've already discussed is the fact that it is discretionary. You're not entitled to a reason why the court denied it, and you're not entitled to have your writ heard. And in practice, of course, writs are often denied, but primarily for the reasons that we'll discuss. Some of the other requirements, in addition to having to show trial court error, of course, in a writ, you have other requirements that you do have to show to have the case heard by the Court of Appeal. So in determining whether you can take a writ, I think it is important, every time you get that unfavorable ruling or that order, to determine first, there are a few circumstances where a writ is actually your only avenue to have the Court of Appeal hear the case. So you want to make sure that if it is that you're not waiting until the appeal, or you may have waived your right to have the Court of Appeal weigh in on that issue. And one of those circumstances is any type of ruling on a disqualification of a judge. And then also it's important to note when some orders are actually directly appealable. I mean, there are circumstances where you don't have to wait until the final judgment. One great example is a ruling on an anti-SLAPP motion that typically happens very early on in the case, and those rulings are directly appealable. So you want to make sure that you first determine whether you have to take a writ or whether you have the ability to appeal. Other issues that you definitely want to consider are whether this is an important issue for you. Does the issue go to the main thrust of the case? If it does, then that's something that you definitely want to consider in whether you're going to take a writ or not. If the issue is likely to be cured in the course of litigation, for example, if you have a statute of limitations issue and you raise it on a demur, but truthfully, there's probably some factual dispute, there's some factual issues that you need to raise, not disputes, but issues that you need to raise, and it's better suited for an MSJ, then then it's less likely that the court will take that case on a writ, and less likely than that you should take that case to a writ proceeding because that could be cured through an MSJ. And another thing, that should be considered is, should this issue be decided immediately? Do I need an immediate decision, or can this truly wait till the end? And, unfortunately with this pandemic, courts are extremely backlogged with trials. Trials are being set years from now. And so these type of proceedings have been more of a viable option for litigators in order to resolve these important issues. So it's definitely something to consider. Also, in the really rare circumstance you're able to convince your opposing party, you may be able to get them to actually agree that appellate court intervention is necessary and really important before moving forward. So what makes a successful writ? So these are, in addition to, of course, showing, that the trial court erred, there are additional showings that are not required for an appeal. And there's two main showings, and these are the two reasons I will say that most writs are denied. The first one is you have to show that there's no adequate remedy at law. And this requirement is actually codified in the Code of Civil Procedure. And what that typically means is that if you have the ability to directly appeal from the order, then you have an adequate remedy of law, and writ proceedings are typically going to be, a writ will be denied if you have the ability to appeal. Of course, there's always exceptions to every rule, and this one included. So there are actually exceptions, which I'll discuss a few examples later. It's just something to consider and keep on your radar. Even when you do have an order that is directly appealable, it is still possible to have a writ heard on that order. And the second big requirement and second hurdle that you have to jump through in order to have your writ heard is irreparable harm. And a lot of times these two requirements can go hand in hand. And sometimes the same facts can be used to kind of show both, but it's important that you definitely have facts supporting both of these individual requirements. And a good example is when you have an order that requires requires your client to disclose privileged information. That order is typically not reviewable until the end, until you have a final judgment. And so, that meets your, it's not directly appealable. So that meets the requirement of establishing that there's no adequate remedy of law. But that fact also establishes why you need a writ now, because you can't wait until the end of your case, because by the time that you have your case heard, you've already disclosed the information and you can't unring that bell. So, sometimes the facts do go hand in hand, but it is important to have facts supporting each individual requirement here. So let's go through some examples where courts have said that there is no adequate remedy of law in cases. So very common motion, demurrer. Demurrer being overruled, the Court of Appeal has said that an order overruling a demurrer as to all the cause of action can support a writ proceeding, because by the time this issue is heard at the end, the parties will have gone through a needless trial. The Court of Appeal has indicated its willingness to hear demurrers that are overruled as to all cause of action. Another one is an order denying a motion to strike. Again, the Court of Appeal here said if we wait until the very end, after this case has gone to trial, that remedy is inadequate, because these parties would have gone through additional discovery, through trial preparation, and that's just too much delay. We need court intervention now. So the Court of Appeal has said that that is another example where writ review is possible. And another big one is an order on a good faith settlement determination, whether it's granting it or denying it. And in fact, there's a split of authority right now on this issue, on whether writ review is the exclusive remedy, or whether whether you can challenge the ruling by way of a final judgment. So there's currently a split of authority. You'll see that the Oak Springs Villas case says that this is the only way you can obtain review. But then I've included a citation to another case, which says, although it's the preferred method of reviewing these types of orders, it is possible to challenge it by way of a final judgment. So there's a split of authority. Of course, I would always caution to take the writ. And if that gets denied, then you can still try to raise it on appeal. And here are some examples where the court has found irreparable harm, and that requirement has been met. Again, we've talked about this one a lot, and I discuss it a lot because this is one of one of the types of orders that the Court of Appeal will definitely consider in granting a writ, which is any type of discovery ruling that requires disclosure of privileged information. The court completely understands that by the time, you have to go through the case, you've already disclosed the information and there's no way to undo the harm. And so it's important for them to take these types of orders up on appeal or on a writ. So you don't have to wait till the end and after it's already been disclosed. Another example is erroneous rulings that have required you to would require you to undergo two trials. And here's a few examples, at least, of courts of the Court of Appeal granting a writ based on this fact. And this particular case I thought was more unique. This was a case where the trial court granted class certification, but it was based on an erroneous legal assumption. So basically what the way that the trial court issued its class certification would have allowed the plaintiff to be relieved from providing an essential element to his breach of contract or breach of warranty claim on behalf of 19,000 class members. So the defendant here, Honda, would have had to gone through this entire trial without, with the plaintiff not having to prove this essential element of their cause of action, despite the fact that that was erroneous, in order to challenge the decision. And then they would have to go back and retry it again with the essential element included. So here the Court of Appeal determined that there is irreparable harm by not intervening right now, and instead of having Honda and the parties go through this needless trial. Another example is an order vacating an arbitration award and ordering a rehearing. Again, kind of similar to the other case, there's no reason to have the parties re-arbitrate it and then to come back and find out that the court erred and have to do it all over again. So here the Court of Appeal said that this is establishes a showing of irreparable harm for the court to intervene now instead of wait until a final judgment. So like I said, there are exceptions to every rule. And so there are actual circumstances where, despite the fact that you have a right to an appeal, writ review has been found to be warranted. And one of those is an order granting or denying a motion to disqualify counsel. And the courts have said that they recognize that disqualification of counsel should not be allowed to kind of hover over the proceedings for extended period of time, because, as I mentioned before, appellate proceedings take a really long time. They can take a year and a half, 2 years. In this case, the courts have said that they would prefer to have this type of order resolved through writ proceedings because it can be done on a quicker time frame. Another example is actually an order awarding cost. Typically, when you have a judgment, a post-judgment order awarding cost is directly appealable. And so in this case, the court took the issue up on a writ because the judgment had already gone through an appeal. It had already gone through the long, prolonged process of an appeal. And the court here said, it's not fair for the parties to have to go through another long appeal to have this issue addressed. So they utilized the writ proceedings to kind of get it done quicker. So what makes a successful writ in terms of how you present your issues? And this is also really important. So that, despite the fact that the trial court erred, there are ways to kind of present your issue to the Court of Appeal to make it even more attractive. One of those is ensuring that the issue that you're presenting is truly more of a legal issue, that there's not too many facts involved. This isn't, an issue of determining whether there's substantial evidence. Purely legal issues are more likely to be taken up on writ. To the extent that you have an issue of first impression, there's no other case out there addressing your issue. That's a great issue to take up on a writ. or issues that have a lot of impact for litigants throughout the state. That's another great one to kind of take up on a writ and will be more attractive to the Court of Appeal. Now, I know I said I wouldn't give you all the information that you need to know, everything there is about a writ, but I do want to at least explain to you some of the basics of a writ. One of those is the difference in terminology between an appeal and a writ. So in an appeal, you typically have the parties are the appellant, the appealing party, and then the respondent. And in a writ, you technically have three different categories of parties. You have the petitioner, who's the party seeking the relief. You have the real party in interest, who is usually your opposing party, the party that prevailed on the issue. But in addition, you have the respondent, who's technically the superior court. So if you note, all writ proceeding cases, Court of Appeal cases, are usually Smith or X versus superior court, because technically the superior court is the respondent in all writ proceedings. Doesn't mean that the superior court can respond, because they can't. But technically, again, going back to that definition of what a writ is, it's an order from the Court of Appeal to the superior court. And so for that reason, the respondent is always the superior court. A writ is made up of two main sections. The first is a petition, and it's actually very similar to a complaint. You have numbered paragraphs. You have the ability to include a prayer for relief. And importantly, a petition has to be verified. So everything you include in the petition has to be verified. And then you have a second section where you argue the error. So you have your memorandum of points and authorities. So your writ will include an actual separate verification. You'll also have to have exhibits to support your writ, which is mainly consists of the trial court record. And then you'll also, similar to an appeal, have your certificate of interested parties and your certificate of compliance. Now, this is a very important aspect of a writ, and to the extent that you know you have a really important issue, and you're, let's say it's that MSJ, on a really important issue, or you have that case where you have you're fighting over the disclosure of privileged information. It's important to kind of recognize that early on in order for you to adequately prepare the record for your writ. Because if you do not provide an adequate record for your writ, it will be summarily denied. And I've unfortunately have seen it happen where the party did not include, for a denial of a summary judgment motion, the party did not include their answer, which contained the affirmative defenses, and the writ was denied on that ground. It's very important that you provide an adequate record. Of course, first and foremost, you want to include a signed order that's being challenged. So if you know ahead of time that this is going to be something that you might be taking a writ on, you want to have a plan to secure that signed order as soon as possible, especially for certain writs that have a much shorter timeline. There's some writs where you have to submit them within 10 days or even 20 days. So you definitely want to have a plan to have that order secured as soon as possible. You also want to include the relevant trial court documents in your record. So that's generally, it's going to be all the documents that you submitted to the trial court in support of your position or of the motion or opposition. So you want to make sure you include that. And then another big aspect is the reporter's transcripts of the underlying proceedings. So again, this is where, it's important to know whether you're going to be taking a writ, because you want to make sure that you have a court reporter present at that hearing. And you want to make sure that you tell the court reporter, I'm going to need the reporter's transcript very quickly. So it's important to kind of relay that, and especially for the writs that have a quick turnaround. So there are two main types of writs. The first one is a statutory writ, which unsurprisingly are writs that are authorized by statute. The deadlines for a statutory writ are set by each statute. So they vary. Like I said, they can run from 10, 20 days, but they vary from statute to statute. I think the important thing to note with statutory writs is that there is a possibility that the deadline to file the writ can be extended by Code of Civil Procedure 1013, or even the court's discretion, but it will typically be laid out in the statute itself on whether that's a possibility. The second type of writ is a common law writ, which is basically the ones that are not authorized by statute and created by the courts. Technically, there's not really a deadline per se for common law writs. It's kind of a laches type deadline, but I will note that I think the general consensus among the courts is that a common law writ should run the same deadline as an appeal, which is 60 days from notice of entry of the order. So you definitely want to have a goal of filing it within 60 days, but truthfully, you really shouldn't wait even that long to file a writ in the Court of Appeal because these are, extraordinary proceedings. So you want to get them filed as soon as possible. Some examples of statutory writs, and these are kind of the more common ones that you'll probably deal with in your day-to-day practice. Writ on a motion to disqualify a judge that has a 10-day deadline. A writ for a motion to change venue that has a 20-day deadline. So these are really quick turnaround times. A writ from a motion for good faith settlement is also 20 days, as well as a writ from a motion for granting summary adjudication as to part of your motion, or a denial of the entire summary judgment motion. And that is also 20 days. And some common examples of common law writs are a writ from an order overruling a demur, a writ from an order denying class certification, and writs from significant discovery motions, especially those related to production of privileged information. Another important thing that you definitely want to consider when you're filing a writ is whether to ask a stay, because you do have that ability with a writ. Typically, in an appeal, there's certain orders, as soon as that you appeal from them, they're automatically stayed, or there's some where you have to take certain steps, such as a monetary judgment, that they won't be stayed until you take certain steps, such as posting a bond. But with writs, typically there's no automatic stay. And so you're going to have to request for the stay. And you want to make a decision whether you want to ask for just stay of enforcement of that specific order, or whether you're looking for a stay of the entire trial court proceedings. Of course, to the extent that you can kind of narrowly tailor it to a stay just to that order itself, I think that's probably preferred versus asking for a broader stay from the Court of Appeal. But before you can even ask the Court of Appeal, you have to ask for a stay in the trial court first. That is an absolute requirement, unless you have extremely extenuating circumstances where there's just absolutely no time to get to the trial court. And so in those cases, I think there are exceptions where you can go directly to the Court of Appeal, but they definitely have to show your extenuating circumstances as to why you weren't able to go to the trial court first. Again, this is where it's important, if you know you have a big issue coming up and you have a big motion hearing, and it's likely to get denied, the court looks like it's going to deny it, you can ask for the stay right after that ruling. You can ask the trial court that right then and there. It doesn't have to be by a notice motion. Whether the court will stay enforcement of the order or the trial court proceedings in an effort to seek a writ in the Court of Appeal. So, kind of knowing ahead of time will definitely benefit you and prevent you from having to go back to the trial court again, either through an ex parte or another motion to request for that stay. So here are some, now that we've kind of like understood, how writs are seen through the Court of Appeals eyes and how the process goes and the requirements. Just wanted to go through 2 examples of, circumstances that may come up on whether you should or should not take a writ. And the first one is the granting of a class certification motion. So a plaintiff brings a wage and hour claim and pleads that all the employees were misclassified and therefore this case should move forward through class action. Plaintiff wins on its motion for class certification. So the question is, should you take a writ or can you take a writ first? Yes, you can take a writ because that order is not directly appealable. So you've kind of established the requirement that there's no adequate remedy at law. The irreparable harm could be that you would have to go through this massive trial now with, X number of class plaintiffs. And so that could be part of your irreparable harm. But whether you should take a writ, it's probably going to be a yes. And it will depend. It will really depend on whether you have a pure legal issue that you can kind of address with the Court of Appeal. Maybe it's an issue of first impression. But there's a lot at stake here because the difference in the damages between a single plaintiff versus, a class action is significant. So it's definitely something you should at least consider and lean towards probably taking that writ. Here's another example where I don't think you should take a writ. So in this case, you have a plaintiff that files suit for medical negligence and medical battery, and the defendant files a demur just to the medical battery cause of action. The demur is overruled. So that order is not directly appealable. So can you take a writ? Yes. Should you take a writ? Probably not. And that's because the value of the writ is low here. The parties, you're probably still going to be engaged in litigation on the medical negligence, and the issue of damages won't be that significant. It won't be that much of an impact keeping the medical battery in the case. So that's the circumstance where you're probably not wanting to take a writ. So the ultimate outcomes of a writ. So once you filed your writ, some of the options that the Court of Appeal has, as I've discussed, is a summary denial of the writ. And that, if you've ever gotten it, it is literally 1 page, 1 sentence that says, the court's considered it and it's denying the writ. And no explanation. But again, the important thing to note is that it does not have any precedential effect. It does not mean that the trial court or that the Court of Appeal did not agree with you on trial court error. It may have been and likely was that it didn't agree with you on whether there was an adequate remedy at law or whether there was irreparable harm in that case. And that's, again, the main reasons why writs get denied. Another option that the Court of Appeal does have, if it's considering taking up the issue, is that it will issue an alternative writ. And that's basically similar to an order to show cause. So the writ will basically say that the court is considering taking this and that the trial court should show cause as to why, the order should not be reversed. And then a third option, another option that the Court of Appeal does have is to issue a preemptory writ. And that's less likely to happen, which is basically it will come right out with a ruling on the issue. It is more likely that if the Court of Appeal will take your issue on a writ, that it will issue an alternative writ instead of a preemptory writ. But these are the options that they have. And I will say they actually do have the option to deny the writ and provide reasons. And so to the extent that that does happen, which is very rare, the reasoning in that writ will be considered law of the case. So that the trial court does have to implement those reasons and take that into consideration when moving forward on in the case. So I am at the end of my presentation. Does anybody have any questions for me? And you can drop them either in the chat or in the Q&A feature. I'll wait a second, see if anybody has any questions at all. And if you can't think of any right now, I'd be happy if you want to reach out to me after the program. I'm happy to answer questions as well. And let me move to the next slide here to give you that information. So here's my contact information. Please feel free to call or email me if you have any questions. Okay, we have a question about, can you talk about good examples relative writs on MSJ denials? I think, again, I think your issue should be more of a legal issue. So if you have, some writs that I see often are writs on an affirmative defenses that kind of get rid of the entire case. Statute of limitations, is a big one that I've seen writs granted on. So you kind of want it to really be a pure legal issue that really is going to get rid of the entire case. And, to the extent that it's pretty clear that the trial court erred, the Court of Appeal is going to be more likely to take up the issue on a writ to avoid the parties and the courts from expending a lot of resources and time to go through a trial. So I want to say, keep it to those pure legal issues. You also don't want to throw too many issues at the Court of Appeal in a writ. You want to keep it to one or two big issues. And so to that extent, if you're able to kind of get rid of the entire case with those one or two issues, those will definitely be the type of cases that will be more attractive to the Court of Appeal. And again, if you have, issues of first impression are taken up on writ a lot. So if there's a case out there that you have that you're kind of battling right now that has a legal issue that hasn't been addressed in a published opinion, you may want to kind of set it up for writ review by, moving for summary judgment or, addressing it in some type of motion. So that's definitely something to consider. And also any issue that really is going to impact a wider scope of litigants in California, that's another thing that will be taken up by writ as well. Okay, let me see if we have any other questions. Okay, we got one more question here. As appellate counsel, is it helpful for you to get involved before the trial court issues the final ruling? I would say absolutely yes. To the extent that you have a big case or maybe a big issue in a case, it is extremely helpful to involve appellate counsel well in advance, to have them there to kind of support you and be your sounding board while you're moving through the litigation. But when you have that big motion that's coming up, I certainly have a lot of my colleagues will reach out to me and tell me I have a summary judgment motion. They'll even have me review the motion, and they'll start to get me involved before the motion is even filed. And I think that's extremely helpful because I can present different cases and different angles for the issue to be set up in a way that will be more attractive if it does need to be taken up by a writ or even an appeal. But if it does need to be taken up by a writ or can be, it's definitely extremely helpful to kind of get your appellate counsel involved early on. So that's a great question. Definitely. Are there any other questions for me that I can answer? Again, if you think of something later or need, have a case specific question, please feel free to reach out to me. I'm happy to answer any questions that you have. Okay, I don't see any other questions.
Well, thanks so much, Arzu. I'm not seeing any other questions popping up either, but just thanks so much for taking your time for really helpful presentation. And for everyone, we placed Arzu's presentation in the chat, so hopefully you're able to download it. If you need me to send it to you, I'm happy to do that as well. And we're in the process of uploading all these videos to our YouTube page. So for those of you looking for CLE on demand, these should be up there pretty soon as well. But thanks, Arzu. And with that, I think we'll wrap it up.
Okay, great. Thank you so much for having me.
Thank you.
Thank you.